Testing 1 2. 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 Testing 1 2.
So I'm going to do
Can you hear
testing
the podium okay
justice
with
6,
that now? Closer?
I think. Oh, yeah, no, I can hear you well from there. So testing 1 2 3 4. So that's Justice 6 by my count. Testing 1 2 3 4. Justice 5. Testing 1 2 3 4. The big chief. Testing 1 2 3 4. Justice whatever number I'm up to or down to.
Yep, 4.
Testing 1 2 3 4. Yes, testing.
That sounds great.
Whoop. And testing 1 2 3 4.
And as we go, I'll EQ them too, so.
Yeah, there'll be a little bit of,
Yeah, we're fine. It'll be 100 times better than just about any other high school. So.
Good morning. I'm Chief Justice Stanfill of the Maine Supreme Judicial Court. Ordinarily, at this point, when we're doing oral arguments, I simply call the case and call counsel to the podium. But this is kind of a special occasion. So we're going to spend a few minutes before we do that. First, thank you. Thank you for having us here. It is one of our great pleasures when we go out every year to the high schools and see the students. And I hope, at least for some of you, it's a pleasure for you as well. I also want to recognize some of the luminaries that we have here this morning, and Representative Amy Kuhn, who is here, and I think was, along with Senator Teresa Peirce, responsible really for inviting us here to Falmouth. Thank you for having us here. We also have members of the school board, Alicia Johnson, who is the chair of the school board, sitting in the front row, together with Emily Martin, the vice chair, and Annalise Larson, also is a member of the school board. So thank you. Thank you for coming, and thank you for having us here this morning. I think you've all met Rachel Oken. Where are you? There you are. Oh my gosh, I just lost. Who I know, who decided, who was gracious enough to help us with what we call the lawyer of the day, so she can answer questions to you, because of course we can't really talk to you. There's a bit of a wall about what we hear, what we think, or anything like that. So we kind of have other people who can help to do that. I believe Mr. Libby, the assistant principal, may be here. I'm hoping somebody might be here. I can't tell. Oh, there you are, back in the dark. Thank you again for having us here. And thanks, as always, to the custodial staff, the AV setup, the auditorium setup. It's always, I know, a lot of work. It looks kind of simple, but it isn't that simple. As I said, I'm the Chief Justice of the Maine Supreme Judicial Court. Some of you, and hopefully actually all of you, understand that we have three branches of government, three co-equal branches of government, and the judicial branch is the third branch of government, one that's usually most hidden. You hear all the time about the executive, i.e. the governor, or the legislature, but you don't hear about us too often, but we are here. Before I was chief of the Supreme Judicial Court, I spent many years as well as a trial judge, and so have been a judge for a number of years. I have chambers, i.e. my office, is in Augusta. Unlike most states where we all are in the same place, we're actually spread around the state and then gather together for oral arguments and conferences and things like that. We're very tradition-laden, and so we do everything in order of seniority. We sit in order of seniority, we walk in order of seniority, and we're about to introduce ourselves in order of seniority, starting with the Senior Associate Justice.
Thanks, Chief. Good morning. My name is Andrew Mead. I've been a judge for the last 35 years. I've served on the Maine District Court, the Superior Court, and for the last 18 years, been a member of the Supreme Judicial Court. My chambers are based in Bangor, but we hold hearings in Portland and Augusta and Bangor in the courthouses there, and you may get one or two people, watching the arguments. It's great to be here today with all of you. It's a beautiful, crisp day. I can't think of a place I'd rather be. Looking forward to these arguments this morning.
And I'm Catherine Connors, and I've been sitting on the bench since February 2020, and I am the only one of my colleagues who was never a trial judge. I went straight from private practice to being an appellate judge. My chamber is in Portland, and I live in York County.
Good morning, I'm Rick Lawrence, and I've been on the bench for 25 years. 22 of those years I spent time on the district court, and then rose to the Supreme Court back in 2022. My chambers are in Portland, and I live in Cumberland County, and very much appreciate the opportunity to be here with all of you. Thank you.
And good morning. My name is Julia Lopez. I am the most junior justice of the court. they're expecting me to make a joke about age, but I'm not going to do it. I am the newest member of the court. I've been on the court for about 6 months. I previously was a trial judge, justice on the Superior Court. I also have chambers in Portland and live nearby, and I'm very glad to be with you all this morning.
And you will notice that instead of going back and forth constantly, we also have an empty seat here, this happens from time to time on a case. Somebody may be what we call recused for whatever reason, and we don't necessarily disclose the reason. That judge has decided they ought not to sit on a case. And so you will see, for those of you who might stay through the second or third arguments, you will meet our missing justice in those cases. Yes, the joke we were expecting her to make is when I talked about seniority, we're talking about seniority on the court, not age. But apparently Justice Lopez falls into most junior in both respects. So we won't reveal the rest of us. All right. With that then, we are ready to begin the first case. The first case before us is State of Maine versus Randal, Hennessey. This is York 24503. Counsel are here, way down there. I understand that the arrangement's a little odd, but if you were up close, it also meant that people couldn't see. So we'll go with this arrangement. I would ask counsel to introduce yourselves for the record, starting with the appellant.
Thank you. Good morning. Rory McNamara for the appellant, Randal J. Hennessey.
Katie Sibley for the state.
Thank you. We are being streamed and recorded, so we are being streamed both by audio and video on the web. If anybody ever chooses to, you can watch other arguments at other times. And with that, I think if counsel are ready to proceed, Attorney McNamara would be happy to hear your argument this morning.
Thank you. May it please the court, Attorney Sibley. The defense expert was excluded in plain contravention of case law and Rule 702. In contrast, the state's...
I note that the green light is on, which means that you have invited us to ask questions right from the beginning. With regard to this expert, I read the report. Can we determine or could we conclude that the judge properly excluded the report because it really didn't express anything that was relevant to, or exclude the expert, because the report really doesn't express anything that would be helpful to the jury?
I think we're talking about the defense expert, just for the sake of clarity.
Did I say?
Yes.
Okay.
No, that wasn't the ruling below. So rulings in terms of relevancy are reviewed for clear error. And that the basis of the ruling below is a 702 ruling, not a relevancy ruling. And we defer, this court defers to judges who are sitting below in terms of relevancy because they are there, they understand the proceedings. But also just an objective examination of that report shows all kinds of things that would have been relevant. And it goes from the central premise that Mr. Hennessey's primary defense was imperfect self-defense. In other words, he acted in self-defense. Perhaps it was unreasonable self-defense, but he needed to explain and would have used the defense expert to explain the psychological circumstances. Some of these
in your brief, you pointed out that the judge's ruling was, well, he didn't express an opinion, so it doesn't get in. That's your argument there. I think we all read the report, and there is no opinion in there.
Right.
If you boil it right down, it's page after page of stuff, and the last 2 pages, he refers to what goes on in the brain when we're confronted with fear, and the fact that ordinary, rational thought kind of falls by the wayside.
I think
is that the thing that you think was of use to the jury, that he could testify otherwise about that?
My recollection, and I don't have it in front of me, was it was much more than the final 2 pages, that it was pretty substantive in there about terms about the thalamus, about the cortex, about amygdala hijack. These are terms that I don't understand.
But don't they boil down to something that everyone knows? When you get really scared, it messes up the thought processes in your head. Is that something that the jury really needs to have an expert tell them happens?
Well, this court's case law certainly, in context about battered women syndrome, which seems pretty intuitive, about delayed disclosure from children.
But those are things that aren't necessarily intuitive. I mean,
I think they are.
You really?
I do think those things are intuitive, and I think that most people have never been in a fight or flight situation involving deadly force or
And
the
does it
threat.
help explain things like, for example, multiple gunshots or something like that?
It absolutely could do that, where you're pressing on a gun multiple times rather than just once, or you're making a decision to have the gun or to use the gun at all, to pull the gun when a man who's much larger than you is lunging at you.
I want to ask something that isn't really touched on so much in your briefs. I'll just do it quickly. But,
Sure.
We all know about self-defense, imperfect self-defense, or it doesn't work coming through the door. But there are different rules for using deadly force in self-defense
Right.
as opposed to just dead.
Right.
Do we have some case law that says, Cardilli and other cases you're well aware of, that basically
Yeah.
says, if you are the person who injects deadly force into this confrontation, you can't invoke the defense because there was no threat of deadly force to be used against you.
Right. But that's a factual question for the jury to decide. That we argue, the defense argued at trial, that the deadly force that was introduced, or at least it was reasonable, it was potentially reasonable for Mr. Hennessey to think, was when a man foot taller and 100 pounds more was lunging at him, when my client perhaps recklessly was armed with a firearm.
Does the law tell you you can bring out your .38 special and drill him at that point?
In a situation where somebody is lunging at you and threatening you, and the night before was pulling at his waistband, we know there's a gun safe on the property. It's an adversarial relationship that I think it's for a jury to decide.
Your view is that there was at least a basis for the jury to find that it was reasonable for him to think that
Right.
the victim actually
And it wasn't just my view.
would have been armed.
Right, it could have been armed. And it wasn't just my view. The state drafted the self-defense instructions, and the judge signed off on them. This was certainly within the realm of possibility. But if I can pivot to the introduction of Detective Rose's expert, which was, I think, in sharp juxtaposition to what happened here. We have an expert, purportedly an expert opinion about trajectory and blood spatter.
And just to put this in context, this detective wasn't offered as an expert in the state's case in chief.
Correct.
Defense goes on the stand and says, this is what happened. Here, the defendant testifies, this is what happened, that was happened. And Detective Rose steps in as a rebuttal expert witness and says, the blood spatter disproves that.
Suddenly
and you're
he's an
saying was that the state should have ahead of time said, we're going to use this guy as an expert witness.
Right, and not just said we're going to use him as an expert, but produced a report such that the defense counsel, in a case where life imprisonment is at stake, could have vetted it, could have hired his own trajectory expert and said, well, no, I completely disagree. We look at the page, I think it's page 152. Oh, no, I don't have the right page in front of me. But that expert report that's in the appendix says nothing at all about trajectory. It says nothing about the credentials of this detective to prepare.
It's much a report of what he saw at the scene, and he did.
Right.
He did a laser study. Apparently, the police
Right.
have these things where you can take a laser picture and recreate a three-dimensional model.
Right.
So he did that, but the details of that weren't in his report. Is that what your point is?
That's correct, and I think that cuts to two things. That cuts to the actual veracity, the accuracy of Mr. Hennessey's testimony about what actually happened, but it also is a form of credibility, bolstering, almost a vouching in sense, because what Detective Rose was able to say is he was not being accurate. He was not being truthful when he testified to those things.
Is there any sense, counsel, suppose we agreed with you that there was a discovery violation here. is there an argument to be made, though, that it was harmless because this evidence and rebuttal from the detective was really cumulative of other evidence that would tend to disprove your client's testimony, specifically that the gunshots were all in the victim's back? I think there was also testimony about some trajectory evidence in the prosecution's case in chief. So why wasn't this rebuttal evidence sort of cumulative and therefore harmless?
So I think there are two components there. First, I want to mention that I think there were multiple errors in this case, and I think it's hard to say otherwise. So we can aggregate, and I do ask the court to aggregate all the collective harm, and they all go to the believability of of imperfect self-defense. As to the strength generally, yes, there was testimony, and I don't think there's any dispute about it in the record that these shots were to the decedent's back. However, there is testimony from both my client, who could be believed, of course, and the fiancé there on the scene, that both of them believed that these shots were fired at the decedent's chest. In other words, as the decedent was looking at, and according to my client, lunging at my client. As to the cumulative potential nature of the trajectory analysis and the blood spatter, I think that's certainly the state would not have felt the need and wouldn't have been able to offer cumulative testimony, wouldn't have been permitted in rebuttal to do so. They didn't think it was cumulative, thus the need to offer that. But also, it's coming from an officer who actually went to the scene.
There's power in expert opinion testimony
An
as
expert
offered
opinion.
in rebuttal.
Correct. Some of the testimony about how shots might have been fired were offered by the medical examiner who examined a corpse and is talking, and this is not meant in disrespect, but in a sterile terms of anatomical position that are difficult sometimes for jurors to understand. But when you have a detective purportedly as a witness up there, that's something that jurors tend to believe.
Can I ask you, you've got 2.5 minutes left, and I'd like you to talk about the prosecutor's closing argument for a moment.
Yeah.
And you have taken issue with a number of statements that you feel constitute what we call prosecutorial error, because there are limits as to what the state can say to the jury because they have the weight of the state behind them. But I want to direct your attention particularly to your assertion that the closing argument said, well, there are only two people at this scene that are still alive. That's the victim's fiancé and the defendant. They each testified really differently as to what happened at the scene. And I think the state said at one point, well, if you're going to believe him, then you can't believe her, and vice versa. And you have challenged that on appeal. And my question is, when you have two witnesses who testified to completely different facts, Jones says the light was red, and Smith said the light was green. Well, if you go with Smith, you are disbelieving green, and vice versa. It's a binary choice. What's wrong with that argument by the state?
Disbelieving is one thing, but another thing, and there were two comments in that category of error where
Yes.
you believe this one or that one. One of the comments was, why would she get up and lie? To that effect. I don't have the language right in front of me. And that is a line, that is a black line, a red line, whatever the color line is, that you're not supposed to cross as a prosecutor. You're not supposed to say, well, one of them is lying. You can say, one of them had the better vantage point, one of them may not have been able to perceive because of this. You can say, which one do you find more credible?
But as you know, the judge instructs the jury as to how to interpret those things. The judge says, if I remember, you may consider whether there's been a motive or a lack of motive to a witness to falsify or to lie.
Right.
So the judge is going to tell them, you can look if there's no motive there. Why can't the state say, why would she have a motive to lie?
Because it's that line. It's a form of vouching, and courts have said, this court has said, when that term lie is used, that nature of implying that somebody is purposefully being untrustworthy, lack of the right term, that you don't say that, because when you are, as Your Honor wrote in the Robbins decision in 2019, when you have that job as a prosecutor, jurors often imagine that you have extra evidentiary knowledge of things, and that's the reason why that line is drawn.
Thank you, counsel. Attorney Sibley.
Thank you, Chief Justice Stanfill, and may it please the court. On a beautiful afternoon in September 2021, Randal Hennessey executed Doug Michoud in front of Doug's pregnant girlfriend, Jamie. Hennessey shot Doug 5 times in the back, and as Jamie knelt to cradle Doug's head, Hennessey put a final bullet directly through the back of Doug's skull, and then he fled the scene. At trial, Hennessey testified that he killed Doug in self-defense, and the jury resoundingly rejected his testimony. Here, the trial court did not err in excluding the testimony of Dr. Chuck Ryland, Mr. Hennessey's expert, or admitting the state's rebuttal evidence. The subject matter of Dr. Ryland's testimony, fear and responses to fear, is not beyond the common knowledge of a layperson. Everyone has felt fear. Everyone has reacted and overreacted to it. The rebuttal evidence directly pertained to the new facts introduced by Mr. Hennessey that the state heard for the first time during his direct testimony. This rebuttal evidence tended to show that Mr. Hennessey's self-defense claim was implausible. It assisted the jury in understanding the inconsistencies between Mr. Hennessey's testimony and the physical evidence, along with the eyewitness statements, and it assisted the jury in determining a fact at issue, whether Hennessey murdered Doug in cold blood or acted in self-defense. Given the overwhelming evidence of Mr. Hennessey's guilt, any perceived error in these evidentiary rulings was harmless. Finally, regarding the state's closing argument, a prosecutor is allowed to criticize a defendant's version of the events at issue as implausible, as unsupported, or as inconsistent with the evidence. That is exactly what the prosecutor did here. She did not assert a personal opinion about witness credibility. She didn't specifically argue it to the jury, and arguing to a jury that it is their role to determine fact from fiction is not improper vouching. For these reasons and the ones articulated in the state's brief, this court should affirm the judgment of conviction and sentence. Happy to take questions.
Counsel, I'm going to go to the issue of the defense expert, which was excluded by the trial judge. You have just argued to us and argued in your brief that fear and response to fear is not beyond the common knowledge of the jury. But that's not, the judge didn't get to that issue. The judge excluded it as not proper expert testimony under the report that was given under Rule 702 because it didn't express an opinion in this case. The judge didn't get to whether the issue would be relevant.
What I think the judge is saying where it didn't express an opinion, the report was not tailored to the facts of this case whatsoever. Mr. Ryland never spoke to Mr. Hennessey, never reviewed.
But that's not necessary. We have allowed, in fact, required that it not be tailored in other instances. For example, which, by the way, all favors the state. Expert testimony to say that when children delay disclosure of sexual abuse, that we understand why that happened, that that's a known phenomenon. Expert testimony to talk about how battered women may react with violence. Expert testimony to talk about what strangulation looks like. I mean, these are all things that have been permitted to be put on without reference to the individual. In other words, those experts are not testifying that this individual did that. They're just saying, these are known phenomenon. Why is this not exactly like that?
I will take Your Honor's example of the strangulation expert.
Which may be your best one. However, some of the others, not so much.
I will go with the strangulation one merely because it is the most familiar, and I believe my colleague, Attorney McNamara, had cited that in his brief. So the reason why this court has allowed expert testimony in that circumstance when it's not specifically tailored to a case is because we have a legal statutory definition of strangulation. And people not familiar with that often conflate choking with strangulation.
Granted, but we don't have a legal definition of delayed disclosure or how battered woman syndrome or even, to some extent, forensic interviewing. And these are all things that are essentially the reason we don't tie them to the individual, because that could cross into vouching for that witness, right? Whether the witness is telling the truth or not. Isn't that exactly what the defense was trying to do here? Not to put in an evaluation of whether the defendant was telling the truth or not, but simply to set the stage that this can be what happens in these circumstances.
But Dr. Ryland also had in his report that responses to fear are unique to the individual. And there was nothing in his report unique to Mr. Hennessey. And when you really boil down his report to what he's saying, amygdala hijack, it is a nice term, but when you boil it down to its core elements, what it is fear and an overreaction to fear.
Well, let me ask a standard of appellate review question. Let's say this is an evidentiary ruling, and let's say the judge said, I am excluding this evidence based on reason X. And as an appellate court, we go, well, reason X is wrong, but it's excludable under reason Y. We're allowed to look at reason Y, aren't we? If any alternative basis exists for the exclusion of that evidence?
Sure, you can, Your Honor, just as this court looks at many evidentiary issues, it's going to review the court's factual findings for clear error and then its ultimate decision, in this case exclusion, for an abuse of discretion.
So what you're saying is even if the judge articulated, I'm keeping it out because it doesn't have an opinion, what you're saying is if you go more granularly, why the report is not useful and you can support the exclusion is because he basically says everybody's different and it doesn't really tie it to the facts of this case.
I mean, it is really important, the reasons why a court does exclude something. I believe it was in the Penley case, I may be confusing that with the Coleman case from a few years ago, where the court had articulated an incorrect reason, but this court ultimately found that the admission of that evidence was harmless.
Can I ask you a question about the prosecutor's statements in
Yes.
closing? Do you agree that we have case law saying it's improper for a prosecutor to accuse a defendant of lying on the stand?
Yes, I mean, prosecutors should not be using what I'll call the L word.
Right. And so I'm looking at the prosecutor's closing argument here, and she says, and the law does not require that you sort out his lies. She's referring to the defendant. That sounds to me like a statement by the prosecutor that the defendant was lying.
Could be very close to the line. Importantly, though, none of the prosecutor's statements drew an objection. And this court has said repeatedly that when a statement is not sufficient to even draw an objection, it is rarely determined to have affected the outcome. And
So
importantly,
your
that
argument is, even though the L word, as you described it, was used, it was not so obviously wrong that it would have required the trial judge to sua sponte on his own jump in and stop it. Is that the argument?
correct. I mean,
What about repeated instances? It wasn't, that was one good example, but it's otherwise, he's spinning. On direct examination, he said the bullets were firing, respond inconsistent. Why? Because he's making it up. That's why. And then on top of that, there's reference to the prosecutor making a closing. It basically said, he's read this, well, I'll read what she said. I suggest to you that Randal Hennessey has read the self-defense statute and has tried desperately to conform his testimony to the physical evidence to fit into all those things. I suggest to you he inserts crouching down business, that he began to describe what he thought would fit the self-defense statute. He can't keep it straight. Why? He used retreating 5 times. Why? Because self-defense statute says that. He's trying to cram his testimony into the self-defense statute, and he's trying, but it's not working. So basically, the prosecutor who knows about the self-defense statute says, I'm telling you, I'm suggesting to you that he's read this, and his testimony is completely fabricated to fill it into that. And it's inconsistent. Why? Because he's making it up. That's why. I realize maybe one statement taken by itself might fly there, but it's like time and time and time again.
Well, importantly, before the prosecutor started talking about Mr. Hennessey's testimony, and this isn't a direct quote, she says, "I'm going to go through what he said on that witness stand and show you how his testimony doesn't match the physical evidence and the eye and ear witness statements." And then she meticulously pointed out, this is what he testified to, and this is what the other evidence
And
says.
that's
so
fine. That's absolutely perfectly fine.
those, what the heart of those comments, what they are getting at, is that his version of the shooting was implausible and unsupported by the evidence, which is a proper prosecutorial
The
argument.
example you just gave is right dead on. That's, that Jones said this, Smith said this, which is more credible. If that's left at that point there, you know, it's point out the inconsistencies, but to say he's making all up out of whole cloth. That's, she's accusing him of lying.
Well, that, she's saying it is implausible and unsupported.
Can I turn to Sergeant Rose's testimony? Sergeant Rose testified in the state's case in chief, but did not offer the expert opinions about spatter, correct?
I believe that is correct, Your Honor, if I'm remembering.
He was not designated as an expert in advance.
I believe that is correct.
The report that was, police report that was supplied to the defendant didn't say anything about those opinions or what it would be based on, correct?
I believe that is correct, Your Honor.
And you knew, the state knew, I don't mean you personally, but the state knew that self-defense was likely the defense. In fact, said that on the record a couple of weeks in advance of trial.
I believe that did come up in the motion in Lemonade a week or two before the trial.
And in fact, this wasn't a whodunit. I mean, there was no question that Mr. Hennessey was the one who shot the victim. It really was going to turn on other things when you have trial, right?
Yes, there was no question.
One would expect that that's probably going to be the defense, plausible or not.
In general, yes, but specifics, no.
Okay. And then, in this case, before the defendant testified, you sent, or you, I'm using you to mean the state in general.
I
know
understand,
you weren't
Your
even
Honor.
trial counsel, so I understand that. The state sent Sergeant Rose's CV to the defense counsel, right? That's before defendant testified.
I think that was the night before.
The night before. Before the defendant testified, you asked the judge to break sequestration and have Sergeant Rose sit at counsel table so he could hear the defendant's testimony.
Yes,
And by sequestration, we mean we exclude witnesses so that they don't hear what other people are saying, and in theory, they could tailor their testimony to that. So he was permitted to be at counsel table, again, before defendant testified,
yes.
right? It is the state's burden to disprove self-defense beyond a reasonable doubt, correct?
Correct.
And so, he was offered as an expert in rebuttal. And we have said time and again that to be rebuttal, it has to be testimony that could not reasonably have been anticipated.
Yes.
Isn't it clear it was absolutely anticipated, and that what happened was he was never designated as an expert, so you could not have done it on your case in chief?
I think from a 50,000-foot view, you could say some version of self-defense was anticipated, but the actual specifics of what Mr. Hennessey was going to testify to, especially given that no physical evidence in Mr. Hennessey's recorded statements never suggested ahead of time, one, that it was self-defense, or
Why
two,
would you
what
not put in his testimony about blood splatter and what it proved in your case in chief? It's yellow, not red.
I thought I saw no red. Yeah, I apologize, Your Honor. I believe some of that evidence did come in. Importantly, the rebuttal evidence was all based on discovery that had already been provided to Mr. Hennessey. The medical examiner's report, the ballistics report, and the photographs that Sergeant Rose took himself. So some of that evidence was already in there, but it wasn't until Mr. Hennessey took the stand and gave his version of the specifics of how this occurred.
And he was talking about who was where, who moved which way, and how the whole thing transpired. And the state was not aware ahead of time. that this is what he was going to say?
The state was not aware ahead of time that Doug was apparently standing and spinning because the medical examiner's report, which demonstrated basically 5 linear shots to his back and indicated he was bent over. How could the state reasonably anticipate that Mr. Hennessey's version was Doug was standing upright and spinning around when he fired him?
One more question. I'm going to exercise Chief's prerogative to go beyond the red lights. Do you agree that we have said, even if it is impeachment or rebuttal evidence, the state has the obligation to designate that expert and disclose that expert in advance?
In its case in chief, Your Honor, rebuttal is very different. The trial court has significant discretion in determining what is proper rebuttal. Proper rebuttal generally has to be, it is proper to repel new facts introduced by an adverse party. That is exactly what occurred in this case.
That is not what my question was. My question
I
was, have we
apologize.
held that even if it might be used for rebuttal and not in the case in chief, you still have to disclose?
It would be hard in this circumstance to provide an anticipatory expert report to address specifics that the state is not even aware of. It would be an obligation the state could, it would be impossible for the state to meet.
Thank you.
Thank you, Your Honor.
Attorney McNamara, are you reserved, I believe, 3 minutes for rebuttal?
We have not spoken about what is probably the clearest federal constitutional Doyle error anybody will ever see. This is more Doyle than Doyle, but for an objection, we have structural error that can't be remedied by any determination of harmlessness, both under the federal constitution and the state constitution. I think I can talk all day about particularized prejudice, but we should also...
What are you saying is the structural error?
What's that?
What are you saying is the structural error here?
The very clear comments on silence post Miranda. You did not call me, personally, the prosecutor. You did not call the detectives. That is so verboten that it jumps off the page. And it will be reversed on post-conviction review if that, I mean, that's, we do not need to go there, though. But I also want to talk about the...
So the statements were post-Miranda. He received his Miranda rights at a certain point?
Well, the comments from defendant was, and this is clearly after arraignment, this is all the way up through trial, this is, he says, I did not talk to law enforcement. So either he has been Mirandized, quite clearly, or he hasn't been Mirandizing and she's nonetheless commenting on his silence.
And you're saying it doesn't matter because he doesn't have any obligation under the Constitution to talk to the prosecutor or to talk to the police whatsoever, and that it's improper to comment and suggest that he did.
Correct. And let's think about this. This is a highly publicized homicide case put in the media. We have several hundred students behind us whose conception of what civics, of what justice is, and what the right to remain silent and not testify is. And they're going to take a misapprehension of what that means if the prosecutor can use it in a way that it was used in this case and comment on it and use it as a penalty. And that's just something that I think, regardless of the particularized prejudice here, should be taken into consideration. I do want to comment also on this notion that we have to have case-specific testimony. We're getting into much newer technologies. Remember when DNA was new? We needed experts to explain that. Think about cell site location experts, not case-specific ones. Think about Celebrite experts that explain these things to jurors so they can understand. The psychological processes of a brain, the expert who has studied self-defense, that is very relevant. And also, not to put this in a way that denigrates the common juror, but to have a doctor on the stand to testify to these things rather than a defendant and a defense attorney being the only ones to say those things. I think those things are very important. It should not be understated.
Can I take you back to the state's point that they couldn't anticipate the exact nature of the defense that was going to be put up by
Nobody
Mr.
can,
Hennessey?
right, but to say that flips the burden here. It says, Your Honor, if I may finish the question. It says that we don't know exactly what the theory will be, but nonetheless, we're not going to put in the evidence that we already have. Detective Rose had already conducted these tests. All the discovery would have required is to disclose the fact that he had done these tests. And that's the way the order of proof works. The state puts this evidence on, and then in rebuttal, if it's been disclosed, Detective Rose can get up and say, you know, it doesn't match with what I did. Thank you.
Thank you. Counsel, thank you for your arguments here this morning. For the students who are here, you probably know this, but we don't tell you what we decide here this morning. Instead, our usual practice is we take it under advisement and issue a written decision in due course. With that, we'll be in recess on this matter. Good morning, you can be seated. It's my understanding that at least some of the students that are here now were not here earlier, so I'm going to take a few minutes to again introduce us and to explain a little bit about what we're doing. Good morning, I'm Chief Justice Stanville from the Maine Supreme Judicial Court, our third branch of government. The branch of government, I would suggest, that is most hidden from view. You usually hear on a daily basis about the goings-on with the governor or the goings-on with the legislature when they're in session, but the judicial branch is the third co-equal branch of government. I also want to apologize for the delay. You will see us engage in an argument in this case, and what we do when we take a break in between is we actually do discuss what we heard. It doesn't mean it's our final discussion, but we do discuss it, and we wanted to take the opportunity to have some of that discussion after the last argument, and I'm afraid it took a little longer than we expected. So my apologies for being late on this. We are very tradition-laden, and we do operate, we do everything really by order of seniority. As the Chief Justice, I'm considered the most senior, though of course I'm not. But we consider seniority by our term on this court. My chambers, by the way, are in Augusta. We sit in different places and sometimes hear arguments in different places in the state. Before I became Chief Justice and was nominated by this governor almost 5 years ago now, 4.5 years ago, to become Chief Justice, I served on our trial courts, both our district court and our superior court, for quite a few years. I'm going to let the other justices introduce themselves. We go, as I say, in order of seniority, so I'm going to turn first to the senior associate justice on our court.
Thank you, Chief. Good morning. My name is Andrew Mead. I've been a judge for the last 35 years, the last 18 of which have been on the Supreme Judicial Court. Before that, I was a trial judge in both the district court and the superior court. My chambers are in Bangor. We typically hold these arguments in Portland, Augusta, and Bangor. But once a year, they let us out, and we get to go to the schools, which is actually very uplifting because typically in our arguments in these grand but old-fashioned courtrooms for the most part, we may have a couple people in the audience, so it's great to have you here joining us. I hope there's some value of it in this for all of you, and it's a beautiful day, and a beautiful day to be here with you.
I'm Catherine Connors. I've been sitting on the bench since February 2020. I sit in Portland, where my chamber is, and I live in York County.
Good morning, I'm Rick Lawrence. I have been on the bench for 25 years. 22 of those years were spent in the district court, and joined the Supreme Court in 2022. My chambers is in Portland, and I live in Cumberland County, and again, as everyone has said, very happy to have the invite to be here. Hope you all learned something from the process, and appreciate the opportunity to be with you.
Good morning. I'm Wayne Douglas. Thank you very much for having us here. It's a pleasure to be here and to see you all. I've been privileged to serve on the courts in this state for over 20 years. I've been on this court for approximately 2.5 years, and prior to that I was on the trial court. Again, thanks for having us here, and I'll turn it over to Justice Lopez.
Good morning. My name is Julia Lopez. I am the newest member of the Supreme Court. I've been on the court for approximately 6 months now. I was previously on the trial courts as well. I have chambers in Portland, and I live nearby, and thank you for having us.
And I will mention that we are ordinarily intended to be a 7-member court. One of our members retired this summer, and we anxiously are awaiting the governor's nomination of a new member of the court, so maybe you won't be the junior member for very long. I now will go to the case that we have here this morning, and I will make a prefatory note. I understand that the counsel for a defendant is a student attorney meaning that she is, on this side, is a student at the Maine Law School. And by our rules, when you have achieved a certain amount of the course of study, you may be admitted to practice under the supervision of a faculty member in our courts. So I think it's very fitting that we have a student attorney arguing on a case when we are doing it in front of students. So the case that is before the court is Penobscot 24-401, State of Maine versus Austin Davis. And I am going to ask counsel to identify themselves by saying their names for the record, starting with the appellant.
Good morning, Your Honor. My name is Marissa Obez, and I am a student attorney for the appellant, Austin Davis.
Thank you. We are being streamed on the web, both by audio and video. You can watch our arguments at your leisure on YouTube. So if counsel are ready, attorney or student attorney Ovis, we'd be happy to hear your argument this morning.
Chief Justice, Your Honors, may it please the court. When a driver refused to furnish a breath test, Officer Haas asked himself, does this person need to go to jail to learn from a mistake they made? It is a police officer's job to enforce the law outlined by the legislature, not to teach the people of Maine a lesson based on his personal agenda. Here, Officer Haas did not provide a direct and clear explanation of the consequences of a refusal. Instead, he misrepresented Maine's implied consent warnings for when a driver refuses to furnish a breath test. We are appealing to this court to apply the Maine Constitution vigilantly, the way it was intended. The primacy approach delineated in State of Maine v. McLean confirms this history of heightened protection for individual rights. As in McLean, this court should examine whether a criminal defendant has waived his criminal right guaranteed by the Maine Constitution and apply that bifurcated standard of review de novo. The language of the Maine Constitution, Maine precedent, the balance of public interest, and the language of our implied consent laws make clear that voluntariness analysis is required under the Maine Constitution. Article 1, Section 5, and Article 1, Section 6 and 6A protect us from unreasonable searches, protect us from furnishing or giving evidence against ourselves, protect us from coercive police activity, all to ensure equal protection and due process in the application of Maine law. To quote State v. Stade, although the state's interest in preventing drunk drivers from operating on our highways is great, the state has no legitimate interest in allowing its law enforcement officers to both ignore the statutory requirements of the implied consent law and to affirmatively mislead individuals about the consequences of their failed.
So counsel, I see that the green light is on. You have just said to us that we should make a decision under the state constitution. And of course, we do have both a state constitution and a federal constitution. But I'm not, let me ask you this. Do you think that the federal constitution, especially given the language of Birchfield, would require exclusion of this breath test?
We do not, Your Honor. We believe that the Fourth Amendment, specifically under Birchfield, does not preclude a voluntariness analysis for a breath test.
Well, that's not my question, whether it precludes a voluntariness analysis. My question is, does Birchfield require that there be an analysis of the consent at all?
Although this is a search incident to arrest, and therefore there is no consent requirement, a search still must be reasonable under the Fourth Amendment, and therefore any analysis under Birchfield would still require that the evidence taken by that officer—
Doesn't Birchfield say that basically You can test, in an OUI case, you can test as a search incident to arrest without regard to whether the person consented?
For a blood test, they do require that there is, in fact, consent. However, under
But this
Birchfield-
wasn't a blood test, it was a breath test, to be clear.
Yes, Your
Actually,
Honor.
can we just back up for a second?
Yes.
You didn't talk too much about the facts here, but what happened, correct me if I'm wrong, is that David was arrested on probable cause of operating under the influence, taken down to the police station, and they have the machine called the intoxilizer. And the legislature and we have set out certain things that the person must be advised, that they can refuse the test, but if they do it, certain things will happen to them. And I guess the officer read that, but then he did something in addition. He said to Davis, okay, if you take the test and it's less than .08, you go home. If you take the test and blow .808 or more, you're going to get a summons. But if you choose not to take the test, you're going to go to jail. Was that a fair summary of what happened back at the station?
Yes, Your Honor. That is almost a direct quote from Officer
So your
West.
challenge, as the chief was pointing out here, is to voluntariness, as whether or not he voluntarily elected to refuse the test?
Yes, Your Honor.
Or put another way, whether he was essentially coerced into taking the test?
Yes, and we believe that this requires a factual analysis.
Well, what did the officer say that you said he affirmatively misled and he misrepresented? What did he say that was inaccurate? Didn't the officer have a choice? Doesn't he have discretion whether to issue a summons or whether to keep him in jail until he's bailed out?
Yes, Your Honor, for the underlying OUI. However, this officer made clear that for this underlying OUI, Mr. Davis was not going to jail. However, when Mr. Davis refused to furnish a breath test against himself, at that point, the officer changed his language and then said, if I don't get a breath test from you, and I quote, we're going to jail.
Well, let's unpack that a little. I mean, why can't an officer say, I've read you all the implied consent. He said, I'm not going to, put you down on the floor and force you to take this breath test, but I'm going to choose to keep you in jail instead of giving you a summons. And why can't an officer think, I really think this is useful evidence, it's data, and it's within my discretion, and I'm going to tell him up front, that's what I'm going to do, and I have the right to do it. What's wrong? How is that coercion to tell somebody something if it's accurate?
The officer did not state up front that if Mr. Davis refused to furnish a breath test, that he would be
No, but
going
once
to
Mr.
jail.
Davis started to say, I don't want to take a breath test, that's when he said, well, this is going to be my choice. And I have the option, essentially, to decide whether to summons or to hold you until you're bailed. And, you don't take a breath test, I'll hold you till you're bailed.
Yes, Your Honor. However, the legislature makes clear that there is no requirement for an officer to take an individual to jail for a refusal. In fact, the implied consent...
Well, it's not a requirement, but I think what Justice Connors said is isn't it within his discretion? I mean, you agree he has the discretion to arrest someone for OUI.
For the underlying OUI,
So
yes.
let's say he never gave him a breath test. He never asked him to take a breath test. He could have just thrown him in jail, right?
Yes, Your Honor. However, this case very specifically goes to whether a breath test was furnished. And in this case, we're arguing that there needs to be a voluntariness analysis to determine whether this breath test was provided.
Counsel, I'm curious as to why you're pursuing that approach, and maybe it has to do with the way the record was developed below, but we have case law in the due process context where we've said we examine whether the circumstances surrounding a refusal to take a blood test have violated a defendant's due process rights, and we look at whether the officer's conduct offends the community's sense of justice, decency, and fair play. Was what the officer did fundamentally fair? And that, you're very focused on this sort of voluntariness prong. Why not this due process issue instead, given our case law that seems to be more squarely in line with what happened here?
I think under a due process analysis, the same would apply, where an officer is required under Maine law to follow the legislature and the intent and written language of the legislature, and to stray away from that and impart his individual idea of whether this person should go
Where
to
does
jail.
it say in the statute that the officer cannot choose to send when the officer is exercising his discretion to summons or put him in jail, that he can't put him in jail if he refuses to take a breath test after he has read him all the stuff that the statute says the suspect must be told? Where in the statute does it say that?
Although the statute does not specifically preclude the officer from making an arrest for the underlying OUI, the statute very specifically mandates that the officer should provide the implied consent warnings, and even just in the basis of not providing the consent.
Which he did. He provided the implied. So I'm still trying to pinpoint exactly what he did wrong.
This officer misrepresented the laws because he did not.
Well, he didn't really misrepresent the law. He just said, I'm going to arrest you if you don't do it. He didn't say I'm required to do that.
In this case, because this officer specifically said, if you do not take a breath test, we are going to jail, where he very specifically said that there would not be an arrest, there would simply be a summons.
Wasn't he sort of cutting Mr. Davis a break? I mean, typically, when an officer arrests someone for operating under the influence, they're impaired. And he had probable cause to believe that Mr. Davis was impaired. It may have been irresponsible for him to allow Mr. Davis to go drive home at that point. And in fact, the officer volunteered to drive him home. So he was sort of cutting him a break, wasn't he?
In this case, this reinforces the importance of a voluntariness analysis at the trial level, where the facts of...
I'm going to follow up, though, on Justice Lopez's question. You keep talking about the voluntariness of whether he, submitted, whether he gave the breath test voluntarily. But when we have frowned in the past upon that, you even cited State versus Stade, that wasn't on the basis. It was on the basis that the Due Process Clause prohibits deprivations of life, liberty, or property without fundamental fairness through government conduct that offends the community's sense of justice, decency, and fair play. Isn't your argument really a due process argument, that it is simply unfair for the officer to threaten that I'm going to keep you in jail unless you consent, rather than whether the consent was voluntary?
Under both analyses, specifically with the Due Process Clause,
I mean, that's the basis for Stade, which did say, no, we're not going to let this go forward, right?
and under the Due Process Clause, we believe that due process would require that the officer provide a uniform communication of the law so that an individual may...
Is the due process argument preserved? And that was sort of why I was asking the question before. You're very focused on voluntariness, and perhaps that's because the trial counsel, from what I could see, was also focused on voluntariness and didn't cite due process principles to the trial judge. So is that issue waived?
Mr. Tavares, in the motion to suppress hearing, does directly reference due process, and therefore our contention is that, in fact, due process is preserved for this issue on appeal, and it is a very important question to look at this case specifically under a due process lens, where in McConkey they say the due process prohibits deprivations of life, liberty, and property that offends communities' sense of justice, as Chief Justice stated, and the actions of this police officer must be analyzed in relation to due process.
But if you look at what the police officer did, he had a person who was probable cause under the influence driving. He had the option of letting the person go with a summons or not being arrested, but he had no idea what the blood alcohol level was. If he had released this person and they'd driven into someone else and caused a fatality, that would have been a problem. So I'm wondering, flipping the coin, does it offend the community's sense of justice, decency, and fair play for the officer to say, I'm not going to release this guy until I know what his blood alcohol level is?
Under the underlying OUI, we absolutely agree. We're not arguing that an individual should be...
Finish your sentence.
An individual should be released if they are not safe to do so. However, we believe that an individual should be given the direct laws outlined by the legislature in order to make a decision that the exclusionary rule and the implied consent warnings allow for.
Thank you. And Attorney Cook?
Chief Justice, esteemed members of the panel, may it please the court. An open can of Miller Lite in the center console, glossy eyes, erratic driving, striking a curb, not remembering it, the smell of intoxicating beverages, these are all factors that led to the probable cause arrest for operating under the influence. Officer Haas takes Mr. Davis back to the police department to perform the intoxilizer test and says, at first, you're not going to go to jail tonight. Eventually, after Davis says that he's going to refuse, the officer gives him 3 options, as y'all previously stated. First one, if you blow under a .08, you go home. .08 or above, I'm going to give you a summons. If you refuse, you're going to go to jail. That is not coercive. If we're going to venture into a consent argument and voluntariness, that is not a misrepresentation of law. The officer did not say, if you refuse, the law says you have to go to jail. He just said, you'll go to jail if you refuse. This was not deceit. This was not trickery. This was not coercive. And the United States Supreme Court has ruled in North Dakota versus Birchfield that a breath test is search incident to arrest. Therefore, consent does not need to be analyzed, and voluntariness does not need to be analyzed under that consent either. And the law court itself has ruled in State versus Loubenier Fitzgerald, pardon my French, that a warrantless blood test upon probable cause that somebody was operating under the influence, that in and of itself, when an officer gives the warnings of a refusal, that is not coercive either. So this law court has itself said that a warrantless blood test was okay. I can concede the rest of my time if y'all would like to start your questions.
So I'm going to go back to one of the statements you made at the beginning, that it's not coercive. I want to make sure I understand what you're saying. That when an officer says to somebody, either take the breath test or I'm going to throw you in jail, that the person shouldn't feel like they've been forced to maybe take the breath test?
The law says under Title 17A, Section 15.
He may have the discretion to do that. I'm not saying he doesn't have the discretion to arrest, but are you seriously suggesting that there was no coercion when you say to somebody, either do it or I'm going to throw you in jail?
For there to be coercion, there has to be deceit, trickery, or misrepresentation. There was none of that. So the officer made a lawful statement.
What was the purpose of the officer saying that? I think we all agree the officer had the prerogative of putting him in jail or not. Officer knew that. Why is he communicating that to Mr. Davis except to try and push him to take the test?
I mean, one of the objectives of the breath test is to promote highway safety and to not take too much time away from the defendant's.
But what was in his mind when he? Police officers don't typically explain to people they're arresting, now I have the prerogative of doing this, this, and this, and this, but he did it here. And if it was not to coerce him, what was the purpose of saying it?
The officer was trying to get the breath test.
Wasn't this the equivalent of we can do this the hard way or the easy way? You can either cooperate with me or you're going to go to jail?
Essentially. But again, that's not deceit, trickery, or misrepresentation.
But it can't just be that those are the only things that constitute coercion. For example, the appellants in their brief give the example of the officer. What if the officer put his gun to your defendant's head and said, either, take the breath test, basically. I have a gun to your head, you're going to take the breath test now? I mean, I presume the state would agree that that's coercive, correct?
Oh, for sure.
But
There's
it's
gonna be no
not
argument for
deceit,
that.
trickery, or misrepresentation, it's brute force.
Yeah, well, that's hyperbole, and of course, if an officer.
But where's the line? I mean, it's to be threatened with jail.
I mean, I would find that pretty frightening, to be told you're going to jail unless you do what I want you to do. I'm going to lock you up.
Sure, I mean, the whole experience, the whole interaction with law enforcement is going to be to some degree frightening, but that does not make it coercive. Returning to the gun example, I think we'd have some bigger issues at hand than probably the OUI.
So
in that
deprivation
example.
of liberty is not the same as deprivation of life when it comes to coercion.
No, Your Honor.
Well, are we talking about coercion, or are we talking about persuasion at saying, you will get this benefit? I am going to put you into jail, which I can do, but here, if I won't put you into jail, if you just take this breath test so I know how dangerous you really are, and I have the evidence that is appropriate. Is it coercion to try to persuade someone to do something and they will get a benefit out of it?
The state would argue no. Again, he was given the three options. All were perfectly valid. Below 0.08 or above, you'll go to jail. Under that, I'll take you home.
Yeah,
If
but
you
talking
refuse-
about it as options is sounding like, do you want rye bread or wheat bread or white bread? I mean, that's not what he was doing. He was basically white bread, wheat bread, or poison.
Again, that was a perfectly valid option under Title 17A, Section 15. Officers do have discretion to do a summons or a warrant. And in this particular one, if an officer is seeing that somebody has committed or is committing in their presence any Class D or E crime, which OUI would fit into, the officer has the discretion to arrest them.
You mentioned before that the officer wanted him to take the test. I guess there's no secret there. I mean, he said to him, I think you should blow, but I'm not going to force you to do anything. And that apparently was the turning point there. So the officer's motivation is very clear. And I guess getting back to all the questions we've been peppering you with, we all agree he has a liberty interest, protected liberty interest. Going to jail is serious business. Once that's deprived, the officer had a motivation to get him to take the breath test and then laid out the options that the chief so vividly analogized to what he's being served. How do we get around that?
I'm not sure I quite understand your question.
I'm just, you're saying it's not coercion, but it's Hobson's choice. Do this and you get a good result. Do this, you get a bad result. Coercion, yes or no? You say that's not coercion, but do you acknowledge that there's a counter argument that someone might consider that to be coercion?
Somebody could, I'd say they're wrong, though.
Well, the reason they're going to jail isn't because they're not taking the breath test. The reason they're going to jail is because he had probable cause to arrest him and put him in jail, and it was within the officer's discretion to choose to put him into jail. So when we talk about, it's not a question of you'll go free and nothing will happen to you versus I'm going to put you into prison. So I don't have any basis for putting you into prison, but I'm going to do this anyway.
Right.
So at what point does persuasion become coercion?
Well, on the one hand, you've got this case, which I believe is not coercion, and then the other case, you have the appellant's argument of putting a gun up to their head. The gun, I think, would be the coercion.
Well,
I'm
again,
not
it doesn't
sure.
seem that it's coercion when when they're back at the station, the officer makes an upfront statement. You're not going to go to jail tonight. We're going to go through this process. It'll be fine. Oh, you're not going to take a test? Okay, then you're going to be going to jail.
Sure.
That doesn't seem to you to verge on coercion?
No, that's not. It's knowledge, it's common knowledge that officers during an investigation can lie. I don't think the officer was lying either when the officer said at the very beginning, I'm not going to take you to jail. But then once Davis got a little bit more difficult, as was a human officer, the officer's like, okay.
Well, was he being difficult or just exercising his right?
I think he was probably just exercising his
He's been given the grace by
right.
the statute not to have to take the test.
Sure. But as soon as the officer gave him the option to take the test and then it became clear that Davis didn't want to, the officer said, okay, now this is going to be a little bit harder. You're not going to take this.
Easy way, hard way.
The easy way or hard way. So now I'm going to give you the three options.
Can I go back to the sort of the basic thing? I think we've gone down one path. I want to go back to Birchfield and my French is no better, Lemonnier Fitzgerald. So in Birchfield, the U.S. Supreme Court said that in an OUI could be tested as a search incident to arrest and did not require consent, correct?
Correct.
If consent's not required, then this whole discussion about coercion really doesn't matter.
Correct.
All right. However, in Birchfield, the court was dealing with a blood test, correct?
Correct.
And you can take the blood from somebody without them, physically I'm not talking about in the legal sense, but physically you can take somebody's blood without them consenting, correct? It's a lot harder to do that with a breath test because you have to have the person blow into the intoxilizer. And in fact, the way intoxilizer machines work, if the person doesn't blow with enough force or for a sufficient length of time, and we see this, they will be marked as a refusal because it was an inadequate, sometimes at least, because it's an inadequate sample, right?
Correct.
So without their cooperation, you can't get a breath test.
Correct.
So, and further, in Birchfield, the U.S. Supreme Court, the failure to take the test was also criminalized, which it's not in Maine, right?
Correct.
So in Maine, our legislature has specifically recognized that you have a right not to take the test.
Correct. You have a duty to submit, but it's not a mandate.
Correct. And there are some consequences, including, suspension, additional suspension, and things like that if you don't. But it's not a crime not to do it. And in fact, the statute makes it very clear that you need to be told you have the duty, and if you don't, there may be some consequences, right?
Correct.
But one of the consequences is not in the statute that you go to jail now.
Correct.
So what are we to do if despite Birchfield, if a breath test requires essentially the cooperation or consent of the defendant in order to do it, why do we not, and you have the option to refuse, legislatively authorized option to refuse, why would we not then analyze whether the consent was validly given?
Again, as you stated, the United States Supreme Court has held that a warrantless blood test.
That's a blood test.
Blood test, correct.
And that's not with a statute like ours, which explicitly gave them the option to refuse.
Sure. I think Maine has already protected its citizens further than North Dakota did, because North Dakota, if you refuse, it's an independent and separate criminal offense. In Maine, the statute says that if you refuse, it's not a new separate crime.
But what's the point of even
enhances-
giving implied consent if you can force them to do it regardless of consent?
You're not forcing them. They can just not take it, and it's a refusal. And then the lower
But
sentencing limits are
my
heightened.
point is that that's inconsistent with Birchfield's idea that you don't need consent. And so if we're saying you do need consent, then don't we have to analyze that consent as to whether it was voluntarily given?
You don't need consent. It's a search incident to arrest, and
Then
it's
why do
almost
we
like when somebody.
Then you're saying we don't have to pay any attention to the statute. You can take the breath test from the person without reading them the information in the implied consent? Can you do that?
I'm so sorry, say that again.
Can you take a breath test from a person without reading them the information, the officer reading them the information required
For
by
a
the-
blood test, there has to be consent
For a breath test.
for a breath test.
If the officer says you need to take a breath test without telling them the information that is contained in the implied consent law, can you do that? Is that going to be admissible?
Most likely not. The officer needs to
Okay.
tell them about the
Because there's a
implied consent.
statute that says you have a right to refuse, and the officer's required to tell them that.
Right.
So how is that not say that you need to obtain a consent
Well, it's
that has
almost-
to be at least somewhat meaningful? Putting aside from the question on these facts, whether it was in fact coercive, I'm really just going to don't we need to have a consent that is meaningful if the statute, the legislature has said, you have the right to refuse?
It's almost like if somebody was arrested for, let's say, drug possession. So then, in that case, an officer would do a search incident to arrest. To some degree, you could argue that there's a little bit of consent. If the defendant moves around too much and says, no, you can't take things out of my pocket, you can't search
But
me.
if there's not probable cause, you would need to have consent to search.
Right.
And that consent would be evaluated whether it was freely given, wouldn't it?
Isn't the point, counsel, though, that there might be a statutory grant of an ability to refuse, but there's no constitutional right at stake here? And so what do we import constitutional concepts of consent and voluntariness into analysis of the statute? Isn't that sort of the distinction that you're trying to draw?
Essentially, the state is arguing this is search incident to arrest. There's no need to examine consent or voluntariness. I understand there is a duty to submit, and again, as stated, Maine has protected its citizens by saying there's a duty to submit. It's not a
That's as a matter of
mandate.
statute, not constitution, correct?
Correct.
Thank you.
Thank you for y'all's time.
9 seconds to spare. And Attorney Ovis, I think you reserved 2 minutes for rebuttal.
Under State v. Reese, where the Fifth Amendment analyzes or analysis seeks to determine whether the defendant's confession was compelled, a due process analysis asks whether the state has obtained the confession in a manner that comports with due process. In this case, those considerations must be evaluated under the totality of the circumstances. And although we do not concede or argue that this case might manifest in coercion, it is important for the fact finder, in fact, to make that determination. We're asking that even if, for the example, if a person is held at gunpoint and required to take a breath test in an already coercive environment under Bridges, a voluntariness must be used in order to consider whether that police activity was in fact coercion and therefore undermines the voluntariness of that individual.
Well, but I'm going to go back. Is it really the police conduct that we're concerned about or the actual voluntariness? If the consent is only required by statute and not by the Constitution, it doesn't, I mean, you know, somebody might say it was bad conduct, but I knew what I was, they may still be voluntary. They may have understood what their rights were and be voluntary. I mean, for a due process analysis, are we really focusing on the effect on the defendant, or are we focusing on the conduct of the officer and whether it comports with notions of fair play?
Your Honor, we believe that it should be, that a voluntariness analysis should be both. It should analyze both the understanding of what a reasonable person would understand in the circumstances, being in a police department with his hands behind his back at night, with this officer who has a gun, and also the actions of the individual police officer. We have these implied consent warnings, so then officers can communicate the law. Your Honor, may I
You can finish your sentence.
Under the legislative intent, and that is outlined and in every pocket of every officer. We're hoping to clarify that for officers.
Thank you. Thank you, counsel, for your arguments here this morning. As is our usual practice, and for the students who are here, we don't tell you what we decide here today. We take the matter under advisement and issue a written decision in due course. I will mention that in addition to student attorney Ovis, I assume having your first appearance in front of this court, it is my understanding that Assistant District Attorney Cook, it is also your first appearance in front of this court. Is that right? And usually, we invite counsel who appear in front of us for the first time back with us to take the greetings of the court in a personal way. But I'm afraid when we do it at a school, you don't get to do that. So you get to, next time you come, you get to say again that you were a first-time arguer. We also don't do it with students, so we don't count this as your first-time argument either. So with that, we will be in recess until the next case.
All rise.
You may be seated. And thank you for being here and for having us. I think we've switched some students again. Earlier this week, we were at another high school that didn't have enough students to fill this room, so this is rather a larger school, I think, than where we were earlier in the week. I am Chief Justice Valerie Stanfeld from the Maine Supreme Judicial Court. I always like giving the civics lesson, which probably all of you know, which is that there are three branches of government, three co-equal branches of government. The executive, which is personified by the governor in this state, the legislature, and we have two members still, no, one member of the legislature, in fact, here with us today for this argument, and the judicial branch. And so you hear a lot usually in the papers and on the news, you know, about what the governor's doing and what the legislature's doing. You generally hear less about what we are doing. So that's part of the reason we like to come out to the schools so that you can get a glimpse into the judicial branch. Ordinarily when we come out in a courthouse, I would just immediately go into the case, but I think it's worthy here of making some comments. We are ordinarily a panel of 7. There are 7 Supreme Judicial Court justices, but we had a retirement earlier this year, and so that's why there are only 6 of us here today. We are waiting anxiously for the governor to nominate another member. That person would then go in front of the legislature for confirmation. I have my chambers in Augusta. We sit in different places in the state, which is actually very unusual. In most states, everybody comes together and stays all the time in a Supreme Court building. We don't do that here in this state. We sit in different places where it may be convenient for us to have our chambers and then come together when we do arguments or conferences or other business of the court. Much of our work, though, is done in solitary in our offices when we're reading and being very academic about all of the things that we have to do. I am going to turn to the other justices, and we always go in order of seniority, meaning length of service on this court, not even in the court as a whole. Many of us, with one exception, who will have been trial judges before we were on this court. But I'm going to turn it over to the Senior Associate Justice.
Thanks, Chief. Good morning. My name is Andrew Mead. I'm the Senior Associate Justice. I've been a judge for 35 years. I've served on the Maine District Court, on the Superior Court, and for the last 18 years I've been on the Maine Supreme Judicial Court. As the Chief pointed out, we are road warriors. My chambers are based in Bangor, so we travel around quite a bit, but one of our favorite times of the year is to come and bring what we do to you folks. Really looking forward to it. Thanks for being here.
I'm Catherine Connors. I'm the one that was never a trial judge. I think I started in February 2020, coming directly from private practice, and my chamber's in Portland, and I live in York County.
Good morning, I'm Rick Lawrence, and I have been on the bench for 25 years. 22 of those years were spent on the district court, and joined the Supreme Court in 2022. And my chambers are in Portland, and I live in Cumberland County. And thank you very much for having us here.
Good morning. I'm Wayne Douglas. Thank you for having us here today. It's a pleasure to be here, see all of you. I have been on this court, had the privilege of being on this court for about 2.5 years, and prior to that, I was on the trial courts for a number of years. My chambers are in Portland. I live in York County. And again, good morning, and thank you for coming.
Good morning. My name is Julia Lopez. I am the newest member of the Supreme Court. I was just appointed at the end of March, and so I'm about 6 months into the job. I previously was on the trial courts. I also have chambers in Portland, and I live nearby, and I hope you all enjoy the arguments this morning. It's great to be here.
Thank you. With that, then, I think we are ready to go into our next case, which is York 2546, Aldarraji versus Alolwan, and I'm sorry for butchering the name. and counsel appear to be present. I would ask that you introduce yourselves by saying your names for the record, starting with the appellant.
Yes, good morning. Colin Chard for Tabarek, Aldarraji.
Good morning. Attorney Mayron Berger for appellee Tareq Alolwan.
Thank you. And counsel, we're happy to hear your argument. I will say at first that we are being streamed on the web, both by audio and by video. And as I said earlier, that means you can watch us anytime on YouTube. And counsel, if you're ready to proceed, we'd be happy to hear your argument this morning.
Chief Justice, Justices, may it please the court. No subordination nor preference of any one sect or denomination to another shall ever be established by law. This is the law of the land. Article 1.
Counsel, I see that you left the green light on, and as I understand it, you're making an argument that a Maine statute that only recognizes religious marriages that are performed either by Quakers or Baha'i and not other religious or other religions violates your client's rights under the First Amendment because it doesn't recognize her religious marriage in the Islamic faith. Is that correct?
That is correct, Your Honor.
So doesn't that, even if assuming you were correct, if the statute is unconstitutional, doesn't that just mean it's not valid and it doesn't help your client?
It sounds as if the court speaks of remedies here, and I've engaged in some analysis concerning the remedies available to litigants who challenge a statute like this one on the basis of...
Well, we can't rewrite a statute. That's for the legislature. The legislature has to determine how to write the statute. So we can't rewrite it. We can say it may violate the First Amendment, but we can't rewrite it, can we?
Well, I believe that there is flexibility in the remedies available relative to under-inclusive statutes. As set forth in my briefing, this court does have the authority, pursuant to the authority cited in my brief, to engage in analysis to craft a remedy, including extending the benefit conferred upon two sects, which has not been conferred on any other sect here.
Counsel, that assumes that Maine law even applies. Does Maine law apply here? I know the parties appear to agree that it does. I don't know that that binds the court. Why does Maine law apply?
Well, let's speak of choice of law. I think it's technically called conflicts of law principles, Your Honor. I'll sometimes refer to as choice of law principles. So we're talking in the context of matrimonial law. There is an option as between what is termed lex domicilis.
Let's talk about the facts first. The putative wife and the putative husband are in the United Arab Emirate, correct? Then there's an imam who's in Portland, but the physical presence of the couple is in the UAE. Is that correct?
Yes, Your Honor.
At the time of the marriage we're talking about.
Yes.
And so isn't our law, as with most states, in choice of law as to what the proper law we look at for choice of law in marriage, where the physical presence of the couple is? So isn't the right law here the UAE Sharia law?
No, Your Honor, that would not be the correct law, although the sort of the principle of lex loci celebrationis, which is apply the law of the place where the celebration happened. I cite in my brief case law relating to Maine's interest, its interest in determining the marital res of its inhabitants.
So if
Well,
a couple from Maine goes to Las Vegas.
Thank you.
And gets married in Las Vegas, are they getting married under Maine law?
I mean, don't we just say, are you validly married in Nevada? And if so, you're married.
That is one way of making a determination.
Well, to be clear, I mean, are you suggesting, I mean, it seems like to apply Maine law and all the our things, you're saying if you go get married in Vegas or New Hampshire or wherever, and you come back to Maine or you come to Maine, now you have to jump through all the hoops in Maine marital law to make sure it's a valid marriage?
Oh, well, no, Your Honor, because these same conflicts of law principles, and I believe even our statutory law here in the state of Maine dictate that if valid in another state, then valid in any other state. This is a principle of comity.
So why
right?
wouldn't that apply to a marriage in another country? Why shouldn't we have the same principle of law if you get married in the UAE, as in this case, or any other country? We look to see whether it was valid there, and if so, and we have a statute, right, that tells the courts here whether to recognize such a marriage. Isn't that correct?
Well, we do have certain statutes here, Your Honor, among them 19A, Section 658. But to your question, which I think was, why are we applying Maine law? We are applying Maine law because Maine is the forum state where the marriage is being adjudicated. Maine is the intended and actual domicile of the parties. The UAE has no interest in the marital status.
So let's go back to the Vegas hypothetical.
Right.
Why, does Nevada have any interest in, if you have two residents of Maine who go to Nevada for a quick Vegas wedding and then come back here immediately? I think you've agreed that we would still apply Nevada law in that case to determine whether the marriage was valid. Why is this any different?
Well, this is different. I'm not sure that I do agree that a district court and in turn this court would apply Nevada law in that instance. The court must engage in a conflicts of law analysis. This court has adopted choice of law principles as set forth in the restatement second.
In determining the validity of a marriage, have we adopted that?
No, this is actually a novel question for this court.
So what rule should we adopt?
Well, this court should adopt the principles set forth in the case that I cited, which dates back to the 1800s, I believe, which is sort of a precursor to the restatement. And there are various factors to consider. I think the principal factor to consider is the actual and intended place of domicile of the parties to the ceremony.
So if you go to Vegas, but you're already Maine citizens and you plan to come back to Maine afterwards, it doesn't matter whether it was a valid marriage in Vegas. You still have to do all of the steps that are required by Maine law to make it a valid Maine marriage?
Well, let's spin that out a little, Your Honor, in the context of this case. Because in this case, there is an alternative statutory path to the marital union that has been a component part of our legislation here in the state of Maine since Maine entered the union. This has been maintained, extended, recodified.
And you're talking about Section 658 that recognized originally marriages performed by Friends or Quakers at meeting?
Yes, Your Honor, because I believe the court was speaking of processes for registering foreign ceremonies, but I think this court must agree that Section 658 dispenses altogether with any requirement upon the parties to engage in the paperwork and bookkeeping related to a foreign ceremony.
Well, not
instead,
entirely.
Your Honor, it places and I think this is an important factor to consider in this analysis, that under 658, there is a burden upon the clerk or record keeper of these two enumerated sects to return to a clerk, a municipal clerk, a record of the wedding ceremony. The burden is not on the parties. All right, what has been done here is that this religious wedding, which has been found by the court to have occurred, and which everyone agrees occurred according to the rules and principles and forms practiced in
Counsel, let me ask you this. If it turned out that the wedding ceremony performed in Dubai or the UAE was valid under that law, doesn't that benefit your client?
Well, certainly, Your Honor, that any participant in a ceremony such as this has a reliance interest in the minimum that they are actually married.
If it was a valid marriage in the UAE, does that benefit your client?
Well, if counsel in this case had elected to develop a record attempting to prove...
This case was dismissed on a motion to dismiss, right? So there was no record developed, was there?
Well, but that is the problem, isn't it? The trial judge down below said that there was no information about that.
I believe the quote was, they were not legally married in Maine or anywhere else, which is a conclusion of law with which my client disagrees.
If you were to write the decision that we're going to issue, what would it say? If you could draft it, what would it say?
The holding of the decision, not the whole thing.
Right. Yeah. I didn't mean a 15-page. You have 56 seconds left, but if you can compress that down to what you want our holding to be.
My holding, all roads lead to strict scrutiny, section 658, does not advance a compelling interest in the most narrowly tailored fashion.
If we were to determine that the analysis, that the trial court should have analyzed whether this was a valid marriage under UAE law, is your view that we should remand it for the trial court to do that analysis in the first instance and development of the record in that regard?
No, Your Honor, that's entirely unnecessary because it is a valid marriage under the laws of the state of Maine, under our historical section 658
I'm
exception.
asking if we find that the choice of law was done incorrectly and what the court should have done is analyze it under UAE law, can we make a determination as to whether it was valid under UAE law, or do we need to remand for the trial court to do that in the first instance?
No, there's no basis for this court to make a determination of that sort.
So there'd need to be a remand.
That is an option available to the court, among others set forth in my brief.
Thank you, counsel.
Thank you.
Attorney Berger.
May it please the court. There is no need to reinvent the wheel in this case. The wheel has been long invented and long been turning without issue. That is the heart of this case. In 1820, over 2 centuries ago, the legislature of Maine rejected common law marriage by passing the 1821 Act for Regulating Marriage and Act for Regulating Divorce. Maine has been a statutory marriage state since then, and this court, as recently as 2019 in Bellevue, has repeatedly refused to infringe on the function of the legislature to define and regulate the institution of marriage in the state of Maine. There are multiple licensure and registration requirements contained in 19 MRS 650 to 660, and they provide clarity and certainty to the citizenry, the courts, and administrative bodies about who or who is not legally married in this state. As the lower court found in this case, appellant complied with none of the required steps. This court need not reach the 658 Quaker Baha'i constitutional question that appellant has asked it to consider. This court should instead simply hold that appellant failed to comply with any of the steps outlined in the statutes and end the analysis there. But if the court decides to reach the constitutional question, it should either hold that appellant's free exercise is not burdened by Section 658, or that Section 658 is facially unconstitutional and must be voided in full. And finally, so that all Mainers have clarity going forward, this court should hold, in line with 4 MRS 1915 subsection 17, that a notarial officer cannot solemnize a marriage for a remotely located individual. Thank you very much, and I'm happy to answer any of your questions.
So the court's findings, to be clear in this case, were that the court, quote, has received no evidence from which to find that plaintiff and defendant were legally married in Dubai, unquote. The court also found that the religious ceremony that occurred in Dubai was in fact completed according to the rules of the Islamic faith, right?
That's correct, Your Honor.
Let's ask the same questions we asked earlier. Why isn't this governed by whether or not it is a legally cognizable marriage in Dubai, and if so, they're married?
Well, Your Honor, I'm not so sure that under Sharia law that this, and I haven't read through all of the scriptures, but I don't know if every single thing was actually followed through with. I think the fact that the imam was in Maine.
That's not the question. The question is it a legally cognizable marriage in Dubai? If they were in Dubai, would they be treated as being married?
If they complied with all of the laws of the United Arab Emirates, Your Honor.
Right.
And
Isn't that the question? Again, it's going back to if you go to Vegas and get married, we don't make you redo it here in Maine as long as it was a valid marriage in Vegas.
We don't make you redo it, Your Honor, but I think the legislature has laid out a way in which through 650 through 656, you can take the license, take it to the courthouse, and have Maine recognize the marriage. I think that's.
But do we have to do that? We have many citizens, I'm sure, in the state who are married somewhere else.
Well, I think in this case, when we're thinking about international law, it could be very prudent just to, for the court to consider. In the UAE, polygamy is, of course, allowed. The woman has to have the permission of her husband to get married.
Well, prudence is one thing, but legal necessity is another. And don't we accord, I know we accord full faith and credit. It's got nothing to do with what the main statutes say, but we accord full faith and credit to marriages in other states. I realize this is another country, but to my knowledge, we would accord the same respect unless a marriage from a foreign country violates a policy, a state policy in Maine.
Marrying somebody who's 10 years old, for example, we would not recognize that because we affirmatively have a policy. That would be against public policy.
But you don't have to go through any procedural registration steps, do you? If a couple moves here from England and they're married, they don't have to register their marriage, do they?
Well, that is certainly true, Your Honor. But I don't think in this case, and to be fair with the court, I was not trial counsel in this case, so I didn't develop the record. But my understanding is that there might have also been issues with the marriage in the UAE.
There may be, but we don't know, do we?
We don't. That's a fair point, Your Honor.
And so that was my question. If we decide that the choice of law analysis was not done properly here, and what the trial court should have done is determine whether this was a legally cognizable marriage in the UAE, is it your view that we should remand for that to be done in the first instance?
Certainly could be done. You also could just analyze the evidence as is. I do think that there is enough for this court to, without knowing every single part of the UAE/Sharia law, I think that there was the problem with the two witnesses not signing the certificate until they were.
Well, there was a finding from the trial court that the court had received no evidence that it was a legally valid marriage in Dubai. I'm paraphrasing. So maybe it's your view that a remand isn't necessary, that we can just rely on that finding.
I believe you could rely on that finding, Your Honor. all of what was submitted to the trial court is attached to as an appendix to this. I think the trial judge had the ability to analyze that and make the decision.
Plaintiff's counsel attempted to introduce some expert testimony, and that was not permitted, correct?
That is my understanding, Your Honor.
Would that expert have been able to testify about the requirements of a legal marriage in the UAE?
My understanding was that it was the imam who was going to testify. I could be wrong about that. I don't know if, they're in Maine, perhaps they could have provided some clarity, Your Honor.
Well, I guess the point
or created more confusion.
I guess my point is there a sufficient record for this court to make any kind of determination, or does it need to be remanded to the trial court to have a fuller, complete record?
Appellee would certainly argue that there's a complete enough record here. The court devoted a half day to this and heard quite a bit of comprehensive testimony.
But wasn't the problem is that neither the court nor the parties in this case actually thought that it was an issue as to whether it was a valid marriage in Dubai, and all of the evidence and arguments focused on the validity of the marriage under Maine law.
That's a fair statement, Your Honor. The arguments were focused on that morning.
And evidence.
Yes, but I also think that there was plenty of evidence provided as to what took place in Dubai, what happened, that the
Well, to the extent that we don't know whether or not it was a valid marriage in the United Arab Emirates, then the record wasn't sufficient to support the presumption or assumptions that everybody was working under in the trial court, was it?
Well, I wouldn't say that, Your Honor. I would push back. I think that there was evidence developed that the marriage would not have passed muster under the Maine statutes, but I also think that Dubai probably has the same presence-based requirements that Maine does.
But the court didn't undertake an analysis under the UAE law.
They did not.
The court made a sweeping finding that the parties are not and were not legally married in Maine or anywhere else. But the court didn't analyze the UAE standards for marriage. Isn't that a missing piece that has to get kicked back to the court if we apply the law where the marriage took place?
That's correct, Your Honor. I think it could also open, if we're going to apply the law of the UAE to determine whether the marriage was valid, I think it only logically follows that in the disposition of property and other issues that their law should apply, and I'm not so sure.
That doesn't necessarily follow, but we don't need to get into that here today.
That may be a bridge too far.
That may be a bridge too far. Can I turn you to the provisions of 19A, section 658? Under that statute, it says, a marriage solemnized among Quakers or friends in the form practiced in their meeting, or, and this was added later, solemnized among members of the Baha'i faith according to the rules and principles of the Baha'i faith, is valid and not affected by this subchapter. And meaning they don't have to go through some of the other requirements that would be the requirements for a civil ceremony, shall we say. I think plaintiff is saying it is a violation, it's discriminatory essentially, it's a violation of their First Amendment rights to free exercise of religion, although it may really be establishment, for the state to recognize what are essentially religious marriages under the Quaker faith or the Baha'i faith, but not under the Islamic faith. What is your response to that?
Well, twofold response, Your Honor. First, I would say I would encourage the court that it doesn't need to invalidate this. It could simply say that, in this case, appellant did not comply with the section 654 requirement.
And that's the second requirement that says the clerk or keeper of the records of the ceremony still must return evidence of it as provided in section 654.
Absolutely, Your Honor, and that could not happen in this case because the witnesses did not sign off on the marriage certificate until
So you're saying we
over a
don't need to
month
reach
later.
that issue?
We don't need to. If we do have to, I don't want to throw the Quaker and the Baha'is under the bus, but I think the only way this court can deal with this kind of quirky statute is to invalidate it as facially.
Well, it's not really that quirky, is it? I mean, if you read it in conjunction with 657, the difference between other kinds of religious or non-religious ceremonies for marriage and Baha'is and Quakers is that Quakers and Baha'is don't have an officiant. They marry themselves. So isn't 658 simply saying, okay, in religions like Baha'i, like Quakers, where you marry yourselves, this is we're not saying that it's not going to be a good marriage. We are recognizing that. And so one of the remedies would be, if there's another religion where they marry themselves, you could say, well, 658 is meant to apply.
I would argue, Your Honor, that that would contravene the intent of the legislature. I think that would render the rest of the subchapter fairly superfluous, and that'll create two classes of individuals: secular people who went through the process.
Well, but it's not really secular versus religious. What Justice Connors is pointing out is that those two particular faiths, Quaker and Baha'i, don't use an officiant.
Yes.
When you go to a Quaker meeting, there is no minister. There is no officiant.
Yes.
You know, it is simply the members of the faith, the friends, meeting. And this, I take it, the same thing in Baha'i. I'm not as familiar. But that's different, isn't it, than whether it's Catholic, Islamic, Jewish, it doesn't matter. All of those faiths have an officiant, so can fall in under the other category, the other statutes.
Yes, Your Honor. So I misunderstood the question a little bit, but I don't disagree with that premise. I'm not sure how that would help appellant out in this case.
Well, it may not, is the point.
Yes, so, you know, I concede that, but still urge the court to affirm, because I don't think that, I do concede that the non-officiant, and I think that's why it probably exists. I wasn't able to find anything on the Baha'i, to be honest, but I did find some on the Quaker and the lack of officiants. I think we don't need to, in this case, I think there's enough evidence on the record that this court can uphold the finding of the trial court, and we don't need to get into whether the UAE law applies, what parts of it do.
But how do we uphold the trial court's findings if we find that the starting point was wrong, that the court applied the wrong law in assessing the validity of this marriage?
I would concede that that would create some problems, Your Honor. I'm arguing that they didn't. I'm arguing they got it right. Okay. And that this court doesn't need to go down that path. And I
So
think
you're saying Maine law should apply under conflict of laws?
it should, because it's the primary domicile of both parties. No one disagrees about that.
That's not the majority view in the United States, is it? Most states say it's where the physical location of the couple is.
I.e., you go get married in Vegas, as long as it's valid in Vegas, you come back, you're validly married in Maine.
That's correct, but there's a minority who does agree with our position, and I don't think the parties are in disagreement on this point.
So you want to make us outliers as well?
We've never shied away from that in other parts of law. Thank you.
Diriga, is that what you said? The state motto, we lead. Thank you, counsel.
Thank you.
And Mr. Chard, I believe you reserved 3 minutes for rebuttal.
Thank you, Your Honor.
The frame is wrong here. We don't need to go to the United Arab Emirates for this. We're talking about...
No, but the parties did.
The parties did, fully intending to be married in their domicile state.
Why didn't they stay? Why didn't they stay here and get married?
Well, as set forth in the brief and as supported in the record, there are certain family members in the Shia sect of Islam who must be present for the ceremony.
Isn't part of your problem that they actually didn't want to appear to be married in the United States? They kept applying, they were applying for FHA mortgages and noting they were single so they'd get better rates and get the mortgage, which wouldn't have happened if they were married?
No, I disagree with that characterization.
Well, I mean, the judge found that that was some of the evidence in this case.
Well, the judge referenced that evidence, but I would note for this court, if it wasn't clear from the transcript, that English is appellant's second language, and having had the opportunity to review mortgage documents myself, I have some concerns as to whether or not an intent can be imputed.
Wasn't your real problem that to the extent that they wanted to get married with other family members present or that were required to be present, okay, they had the ceremony in the UAE, and if they want to be married and have their marriage be valid under Maine law, they could have come back here and had another ceremony.
Right, but Maine has an alternative, a long-standing, to the date of incorporation into
With
the
which
nation.
they didn't comply.
They did comply with Section 658, Your Honor, to the extent, but relief is denied to them on the basis of religion.
There was nothing under 658 with which they complied. There was no certificate, clerk or record keeper didn't file any of the paperwork. And they are not a member of either the Quaker or the Baha'i faith.
May I make 2 points?
You may.
First of all, the argument is, well, the officiant didn't bring the paperwork. The burden's on the officiant to bring the paperwork, not the parties to the marriage. It's not a non-compliance as to the members of the parties to the
Well, if they want their
wedding.
marriage to be recognized, it is.
Second, remember, the statute concerning interpretation of new legislation, we're talking 1 MRS 392, it must be explicitly retroactive. Appellee refers to telephone efficiency being a problem, but it is not, because the legislature did not specifically make that statute retroactive. This is an alternative statutory path. This is not common law marriage, Your Honor. There is a harm to my client that she's being denied this equal protection on the basis of her religion. This court can remedy this. This is not a United Arab Emirates problem.
Thank you, counsel.
Thank you.
As is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. We don't tell you here how we decide. I will note, I guess, Mr. Berger, this is your first appearance in front of this court. It is our custom when somebody argues in front of this court for the first time to invite them back into our conference room and to give them the greetings of the court. However, we don't do that when we're out of school. So you'll get another shot. The next time that you argue in front of the court, we'll remember that that will be considered your first time. So, but welcome to the bar of the Maine Supreme Judicial Court.
Thank you very much. It's a pleasure.
And with that, we will be in recess, not only on this matter, but from the school, although not from the day. We have 2 more arguments we're going to hear in Portland this afternoon. So thank you for having us here this morning. Court will be in recess.